Hey everyone, Harry here to talk about a omnibus motion scattershot covering all kinds of claims about discovery that Donald Trump now has filed in the January 6th prosecution before Judge Chutkan. Okay, to review the bidding a little, the case is in the Supreme Court 9 months or so, returns to Chutkan to try to sort out immunity. And prosecution says that's what we should do first. Let's do that. And we should have the first brief on it. Then they can respond. Trump, on the contrary, said, let's do everything else first. Plus, we should have it first because it's a motion to dismiss. Chutkan essentially ruled for the prosecution and set a schedule. We talked about that schedule and the likelihood that nothing significant in immunity will happen before the election. But Trump is to respond to that motion and state his basic arguments, which are going to focus, especially we know, on Mike Pence next month, October 17th. But she did say, did Chutkan, at the same time, we can go forward on the other motions. I think she actually put it, we can walk and chew gum at the same time. So that's what Trump, in theory, is purportedly doing with an omnibus motion, making all kinds of claims, 30 pages that he filed yesterday, except, unsurprisingly, he actually attempts to relitigate what he lost before. So the very first point that he's trying to make is, we can't do this until first I want you to go through all these discovery violations and immunity and let us have our say first. But then in general, the theme of the 30 pages, even while it's ostensibly discovery violations, meaning the department didn't give us this soon enough and we have a right to that, things of that nature, it's really from first page, it is all about immunity and why immunity requires dismissal. So in other words, Trump, though ordered to go forward on other things and just respond to the DOJ on immunity, has in fact, I'll just read you, he starts the long motion. The case should be dismissed. It's the only just course of action consistent with the Supreme Court's decision in the immunity case. And he makes that argument. But then moreover, each and every kind of discovery violation or argument about what he's entitled to is all through the prism of the immunity decision. So he tries to get things revisited on her part because immunity has changed the whole game. And his response to what defenses are available says we have to have careful consideration of the presidential immunity defense to do this based on the immunity decision. And as I say, the really main procedural argument he makes that's exactly the opposite of what he's supposed to be doing. The first argument, the court should not permit presidential immunity briefing until discovery disputes are resolved, which is an ironic argument because the discovery disputes that he's trying to litigate here are completely driven by immunity. So he is saying we get to go first on all our things, but what is required for her to do is basically apply the immunity doctrine holding from the Supreme Court, but in very fine-grained discovery disputes. So in these, you have to do that because you cannot charge, one of the things the Supreme Court says, you can't use any evidence relying on official acts. And so what they're entitled to or not entitled to, what evidence should play in the case, what discovery, in other words, should require, what the discovery process is totally a question of immunity. So if you read this brief just fresh, you would think that it is basically a brief about immunity. Now, after that, as I say, there's 30 pages, and it's a whole sort of pell-mell of different kinds of complaints. He also goes through different his discovery request, which he's been making before, to get all this information that you wouldn't normally get in discovery about, to further his claim that basically there was a kind of coordination with the White House, or he wants to hear about who in the FBI was involved in things. There's a limited right under the federal rules for certain discovery relative to your claim, but there isn't, but he's trying to create one to kind of gin up an argument that all of this is politicized, driven by Biden, although I would say he probably would call it now Biden-Harris. He says there's bias and hostility toward Trump for political reasons. And once again, if the court addresses presumptive presidential immunity, a prosecution driven by improper bias and hostility toward the only person who alone composes a branch of government would pose dangers of intrusion on the authority and functions of the executive branch. That phrase, something that the Supreme Court promulgated to decide whether certain official acts are immune or not. So from there's a whole sort of array. I don't think we have to go through the specific individual disputes, but just to understand that basically he's trying to do two things: take the lead and be able to make all these arguments about immunity, and revive arguments that really have no place in a criminal prosecution about how he's the victim of bias or hostility and the like. And all of that is through the prism of the immunity decision. Now, you just always have to think in this case about what lies ahead. So it all seems very weak, inapposite in terms of the governing law, and so you wouldn't expect Judge Chutkan to seize on any of this and to expand discovery rights. But we've just got to keep in mind what will happen above and at the D.C. Circuit, and what could even happen in the Supreme Court. Now, this is not, you wouldn't think discovery disputes are things, if they go against you, you wait for appeal to bring. But when he, cloaks them in immunity and has it all interwoven in that way, might he try to take a discovery dispute and bring it to an immediate appeal, claiming it really is part and parcel of immunity, which is something you can make an appeal of immediately. So, broader context, the DOJ and Chutkan are saying, look, we're going to have to go back to the Supreme Court at least once, so let's make it only once. And Trump, on the other hand, is leading with it in every different way, trying to leverage the immunity decision by the Supreme Court for favorable rulings on really sort of small-grain discovery disputes, and potentially setting up a back and forth to the end of days between the district court and Supreme Court by claiming that anything and everything is about immunity. That's the sort of basic theme of this omnibus so-called discovery motion, which is really a recast in terms of his rights under the immunity decision of the court. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.